You get pulled over for a minor traffic violation. Nothing serious. But before you know it, cops are detaining you and claiming they have a right to search your car. Then they start digging through your luggage and your personal belongings, all under the excuse of an inventory search. Is this legal? Or is this just another loophole cops exploit to search your car without a warrant? I'm Jeff Hampton, former prosecutor turned the people's lawyer, and in today's video, I'm exposing how cops twist the law in order to justify inventory searches, and more importantly, what you can do to stop them. Let's get into it. First of all, what is an inventory search? The Supreme Court, nearly 50 years ago, legitimized this inventory search in the case known as South Dakota versus Opperman. In Opperman, the Supreme Court said that police are allowed to, quote, follow a routine practice of securing and inventorying the items in a car after it has been impounded. But what is the difference between an inventory search and a regular police search? An inventory search is supposed to be only for the purpose of protecting the driver's property from either being lost or stolen during the collection and impounding process of the car. And of course, a regular search is when cops are just looking for good old-fashioned evidence. Now I'm going to tell you, regardless of what a cop may tell you, an inventory search of a car is still a search and it should be protected under the Fourth Amendment. Now here's the loophole cops use. Let's say cops pull you over for a traffic stop, they walk up to your car, and they all of a sudden get a hunch that something might be illegal in your car. Maybe it's based off of something you said or your behavior, or maybe even something you didn't say. And as a result of that, they ask for your consent to search your car, and maybe you say no. They have no drug dog available to search, and they certainly don't have probable cause, so what exactly can they do? So what do? Maybe they start walking around your car. They look for an equipment failure, or maybe they see an expired registration or some other ticky-tack traffic violation, and now they rely on either some state law or some police policy that gives them the discretion to tow your car. And in the process of towing your car, they can now perform an inventory search. But in reality, they were only doing this in order to find out what was inside your car. Now let's set the record straight. It is true that police are allowed to search your car if they're towing it. Maybe after you've been arrested, or maybe after a car accident if your car is blocking traffic. But these inventory searches are meant to protect your property, not gather evidence of a crime. The critical flaw here, when officers stretch their authority under an inventory search in order to just be snooping around your car, your rights are at risk. So why do we need an inventory search as a Fourth Amendment warrant exception to begin with? The court in the Opperman case said that inventory procedures, quote, developed in response to three distinct needs: the protection of the owner's property while it remains in police custody, the protection of the police against claims or disputes over lost or stolen property, and the protection of the police from potential danger. In light of this, the court gave us a three-pronged test to determine if an inventory search is legal. Number one, the vehicle must be lawfully in police custody or control. In order for that to happen, you must either be detained or arrested so that the police now have custody over your vehicle. Number two, and very important here, the inventory must follow departmental procedures and policies based upon something the police have already come up with. Number three, the search must be reasonable. Now, what does that mean? Well, that means the police must create an actual list as an inventory of the items in the car, as opposed to it being a loophole where cops can just search through whatever they want. Now, the Supreme Court did put some limitations on inventory searches. In fact, in the Supreme Court case of Colorado versus Bertine, the Supreme Court said, and I quote, "A warrantless inventory search and seizure might be invalid if the accused can show the government action was in bad faith or for the sole purpose of investigation." This is critical because why cops were searching your car makes all the difference. So how do we stop cops from using this loophole of inventory searches against us? Number one, always look for police inventory policies. The first way to stop inventory searches is to see if the cops are following an inventory policy that is both written out and provides standardized procedures they must follow. The U.S. Supreme Court has been very clear. When they analyze these searches, they're looking to see, was there a policy already created, and are the police following that policy to the letter? In fact, in the Bertine case, the Supreme Court said that the police must have, quote, a single familiar standard to guide police officers with limited time and expertise. In fact, in that case, they mentioned if the police do not have a written out inventory policy or if they don't follow the policy they have written out, the search is unconstitutional. This brings us to the famous case of Florida versus Wells. In this case, the Florida Highway Patrol wanted to search a locked suitcase in Mr. Wells's trunk. But the Supreme Court ruled that the Highway Patrol violated his constitutional rights because, quote, the Florida Highway Patrol had no policy whatsoever with respect to the opening of closed containers encountered during an inventory search. And absent such a policy, the instant search was not sufficiently regulated to satisfy the Fourth Amendment. So number one, always look for police inventory policies. And number two, always look for labeled items on the police reports. So the second way we can stop cops from performing these inventory searches is to look specifically at how cops labeled each item they included on their police report and what they considered them to be. For example, in United States versus Johnson, the court held that a so-called inventory search was illegal because even though police listed the items as inventory, they named some of the items as being evidence. The police did not clearly label them as being held only for safekeeping of the driver, which was required under their inventory policy. The Supreme Court made it crystal clear. They said that an inventory search cannot be, quote, a ruse for a general rummaging in order to discover incriminating evidence. Now, some of you have asked me from the comments in some of my previous videos, but Jeff, what if they want to actually do an inventory search on a locked or unlocked container in your car? Well, remember, courts have upheld inventory searches of locked or unlocked containers if the police are specifically following their inventory procedure. So the first thing to do with inventory searches like this is to look and see, does the police department have a written out inventory policy? Does it speak about locked or unlocked containers? Does it tell the cops what to do? The more ambiguous that policy is, the more you have room to say that they were just searching for evidence. And even if it does provide that in their policy, did they follow it to the letter? Look, we all know when something seems off when we're dealing with the police. You have to look at the real reason why cops were trying to search you, not what they claimed it was. A classic example of this is the case I mentioned earlier, United States versus Johnson. In that case, cops, there they were, ready to arrest Mr. Johnson as he was walking out of his residence, but they didn't do it. They waited for him to get in his car, and then as he drove off, they stopped him in the middle of the road. They came out with guns drawn, and as they approached him, guess what they did? They decided to arrest him for obstructing the roadway, even though they stopped him in the middle of the road. And then they used that as a basis to inventory search the vehicle. And the court saw through this and understand the real reason they were trying to get to him was only to get to the evidence they thought existed in the car. Another classic example of this is the New Jersey Supreme Court case of State versus Hummel. In that case, the police seized a woman's purse in order to do an inventory search back at the police station, all because she asked for a lawyer. The court ruled that the woman wasn't even under arrest at the time the police impounded her purse, and the only reason the cops took her purse was because they were frustrated she wouldn't answer questions and invoked her right to an attorney. So what did the court rule? The court ruled, number one, is there an inventory policy? They didn't even have one. But even if they did, they would not have taken her purse when she wasn't even under arrest. And in fact, they then tried to claim, the cops tried to claim, they were also concerned for their safety. But if they were concerned for their safety, when you read the facts, you find out they let her retrieve something from her purse later. So I don't care what the cops call it here. It's important to look at it and see. If the cops claim they're using an inventory policy to search here, you've got to make sure the real reason they're doing it was it just a ruse in order to get to your property, and did they follow what they wrote to a T? Any deviation from the purpose of an inventory search, which is only to inventory items to protect the person being arrested, is illegal under Supreme Court law. Finally, what's the third way to stop cops from using an inventory search against you? Number three, always check your state laws to see if you have extra Fourth Amendment protections, and always lock your containers in your car. Now, this is where it gets interesting, because some states have chosen to give you, as a resident of that state, more protections under their state constitution than the actual federal Fourth Amendment Constitution provides. This is known as the interstitial approach, and thankfully, many states have chosen that you should have more protection than the Fourth Amendment of the Constitution provides, so they amend their state constitutions to provide you more privacy and more property rights protection. In fact, in at least 29 states, those states have at least some additional protections under the Fourth Amendment or private property right protections than you might have just under the federal Constitution. And if you live in a state like New Mexico, Massachusetts, Texas, New Jersey, Oregon, or Washington, your state constitution provides you more protection for the privacy of your car and/or from these investigatory inventory searches. Why do I mention this? Because you should always know your state laws and how much more protection you can receive because of where you live. A good example of this is Autran versus State, a Texas Court of Criminal Appeals case. Mr. Autran was convicted of possession of cocaine because police decided they were going to do an inventory search and open a closed container, being an ice chest and a box, where of course they found the drugs. Texas's highest court for criminal matters, known as the Texas Court of Criminal Appeals, threw out Mr. Autran's conviction based upon, and this is what they said, I quote, Article 1, Section 9 of the Texas Constitution requires police to obtain a warrant to open closed containers in an inventory search. Even though federal law, under the Supreme Court case of Bertine we talked about, would allow cops to do this, the Texas Constitution provided Mr. Autran more protection. But remember, if you happen to live in a state with no extra protection, like a California or a New York, the police only have the Fourth Amendment standard under Bertine to hold them back. So as a result of that, remember, they may use some ticky-tack violation to follow their inventory policy to allow them to inventory your entire car, and they can use whatever they find and violate your privacy rights. Unless they try to break an item in order to see what's inside. This is a classic example where sometimes cops will see a locked container. And maybe they can't get inside, or the person will not tell them how to get inside of the locked container. So what do the cops do? They break it. They literally slam it down in order to get inside or pry it open. Here you have a very strong argument that is an illegal search. Why? Because remember the purpose of an inventory search. It is merely to catalog the items for safekeeping so that the owner can get them back later. If an officer is destroying property in order to see what's inside, we know their real intent. Their real intent was for merely collecting evidence. If the cops were truly only taking that item for inventory purposes, they would take the entire thing. Whether it's a gun safe, whether it's a actual briefcase, maybe it's a piece of luggage, they could just catalog it in and list it without prying it open and looking inside. What does this mean for you? Depending upon your state, you may have extra defenses based upon your state's constitution. Okay, so now let's say that cops are allowed to perform this inventory search. Maybe you can't stop them based upon where you're at and the actual safeguards we've talked about. How far can they actually go? Where in your car can they search? We already covered how to stop cops from searching a locked container in your car, which we talked about. If it's locked, they can't just break it in order to dig into it. But what if they keep searching and they find something and they don't know for sure if it's illegal? For example, maybe they find a pill in a little container and they can't tell for sure if it's like pain medication like Tylenol or if it's something illegal. Unfortunately, there is no bright line rule here. This brings us to the case of United States versus Lozano. Essentially, if you look at this case, it's exactly the same thing I'm talking about. The police actually found what they thought was a pill in a bottle, but they couldn't tell for sure if what was in there was a pill or if it was illegal or not. So the court said, very specifically, they said a police officer may be allowed sufficient latitude to determine whether a particular container should or should not be opened in light of the nature of the search and characteristics of the container itself. Thus, while policies of opening all containers or of opening no containers are unquestionably permissible, it would be equally permissible, for example, to allow opening of closed containers whose contents officers determine they are unable to ascertain from examining the container's exteriors. Now, if you listen to that case, you think police can go as far as they want and search whatever they want. However, there are some areas in your car that cops absolutely cannot look. For example, they cannot rip out the interior of your car or pull the sides of your door panel apart looking for drugs or looking for other things. They are only allowed to inventory the loose items for which they have access to. Remember, the whole purpose of an inventory search is because they don't have probable cause. If they had probable cause, they'd search everything. But because they don't, it's only supposedly for the safekeeping and safeguarding of these items. This is precisely why you should keep as few items in your car as possible and always lock your containers in your car. I have personally seen a handyman driving his truck. Cops pull him over, arrest him for some ticky-tack violation, and then they inventory his car, and what do they find? They find tools that he uses as a handyman, and the cops seized them and tried to use them as probable cause to claim he must have been involved in some burglary because these could be burglary tools. Finally, what if cops already tow your car? They take your car all the way to the tow yard, and now once it's at the actual impound, they want to perform an inventory search. That brings us to the case of State versus Mangold. In that case, the police impounded a van after a car accident, and after it had already been taken to the impound lot, the police showed up and performed an inventory search, and they found marijuana. The twist here? Officers never gave the man involved in the car accident an opportunity to safeguard his own possessions before he left the scene. The Supreme Court ruled that it was an illegal search because the officers should have given the man an opportunity to safeguard his own items. I mean, he wasn't being arrested. He had only been in a car accident, and the cops were using this as an excuse to go search a man's car. So if cops want to perform an inventory search of your vehicle, they must do it before it makes it to the tow yard. Otherwise, it's illegal. So what are the specific steps you can take to stop cops from performing an inventory search on your vehicle? Number one, always refuse any search of your vehicle. If the officer comes up to you and demands to start looking in your trunk, it's very simple. Officer, I do not consent to a search, and I will not answer any further questions without my lawyer present. If the officer chooses to search your vehicle anyway and they violate these policies we're discussing here, then you are going to be able to take this information to your lawyer, and it can be a basis to either file a motion to suppress or perhaps even some type of Fourth Amendment violation when it comes to your civil rights. Number two, ask only the right questions. If your car is only being impounded, let's say you've just been in a car accident and the cops show up, one of the first things you can do is say, officer, is there any way that I can secure my own valuables before I leave the scene? It's important that you ask this question, otherwise they may not give you that opportunity. Secondly, if the officer is going to still tow your car, this happens a lot with DWI cases, you can ask, officer, is there any chance I can have the passenger take possession of the car or call someone to pick up my vehicle? In a number of jurisdictions, police departments have written inventory policies where if someone asks to secure their valuables, or if there's someone else that the owner's willing to turn over the vehicle to, then they are not permitted to perform an inventory search. The other question you should always ask is, am I free to leave now? If the officer says you're free to leave, get in your car and get out of there. But if they're holding you on the side of the road, they may be trying to come up with some excuse to arrest you so that they can then perform that inventory search. By holding you longer than is necessary for that ticky-tack traffic violation, the extending of that traffic stop could render the entire situation illegal and make it an unlawful search. Number three, do not interfere with the inventory or towing process, but still stand up for your rights. And what I mean by that is if you try to stop the cops from inventorying your vehicle, they're just going to arrest you for a serious charge, a more serious charge, and use that as a basis to search as well. But if the officers are searching and you believe it's illegal, one of the things you can do is say, officer, I do not consent to the search of my vehicle for what you are doing right now. And I ask that you stop searching. Here's the key. If we're going to cover the next point here in a minute, why this is important. It's critical that you make it clear you did not agree for them to look through any part of your vehicle. If you happen to have a friend or family member present at the time this takes place, ask them to be a witness to this and to film the entire encounter from a distance so that all of this can be memorialized for the truth. Number four, document everything, both in taking notes about everything that happened, including witnesses giving witness statements, and record everything that takes place. In today's world, it's absolutely legal and you have a First Amendment right to be able to record police interactions. And many times that's the only thing that stands in the way between a judge believing a cop or you determining what actually happened. And finally, number five, invoke your right to remain silent and your right to an attorney. Because if the police are persisting in violating your rights by performing this search, You can only control what you can control. But by following each and every one of these steps, you're able to hold the police accountable by showing the search was illegal, and you're able to make sure that anything the police do moving forward will be thrown out in court. Just because cops throw out the term inventory search doesn't make it magical. If the cops don't follow the requirements laid out by the federal Constitution or your more protective state constitutional standards, and if they're really only doing this search in order to search for evidence, it's an illegal search and a violation of your constitutional rights. Remember, your rights only matter if you use them. We just covered how to stop cops from using an inventory search on your car. But did you know that there are tricks cops use during a traffic stop to try to get you out of your car and search you, detain you, or maybe even arrest you? Check out this next video where I break down 5 tips to stop cops from tricking you during a traffic stop. See you over there.